Regarding the Bhopal gas tragedy. I'm going to share more details for you. You remember, according to government records, about 3,000 people were affected. It affected 1 lakh people. Now, I'm going to bring you more context about the breaking itself. The centre is dismissing the pleas as we speak. I'm going to read out. They've said, "We are thus of the view that the curative pleas cannot be entertained." This was the Supreme Court dismissing a plea seeking additional compensation for the victims of the Bhopal gas tragedy, which killed, as per government records, as I just told you, over 3,000 people and affected over 1 lakh people. Now, I'll bring you more context on this. We'll await as our reporter joins us. The centre had in 2010, you remember, filed a curative plea seeking additional compensation to the tune of 7,845 crores from Union Carbide Corporation's successor firms. This was in favour of the affected families. A 5-judge bench made this decision today, they'd reserved their verdict back on 12th Jan this year itself. My colleague Ananya is with us to bring us more details. Ananya, I know that the centre has, during the hearing, insisted that the enormity of the damage caused by the incident couldn't be ascertained properly at the time of the settlement itself, which was back in 1989. Can you bring us more context now?
Well, definitely, the centre had moved in a curative petition before the Supreme Court in in 2012, and this is a matter that was pending before the Constitution Bench of the Supreme Court, headed by Justice Kishan Kaul. The matter was heard for good long days, and then the order was reserved by the centre by the Supreme Court. However, today the Supreme Court has said that the amount that was there for this compensation was in surplus, and it is the failure of the central government, basically, wherein it could not initiate insurance policies for the victims of the Bhopal gas tragedy. In fact, the Constitution Bench, headed by Justice Kishan Kaul, clearly goes on to say, and I quote, that sum of rupees 50 crore lying pending with the RBI shall be utilized with the Union of India to satisfy the pending claims, if any, under the scheme of the Bhopal gas tragedy. The bench says that the responsibility was on the centre to make good the deficiency in the compensation. The failure to take insurance policies is a gross negligence on the part of the central government, is what the Supreme Court had to say. It also went on to say that it is, the central government has failed to initiate, the compensation policies, and the amount was already in surplus. So there was no need for enhancement of compensation because it is the centre's own stand, and I quoted from the judgment that it is the Union of India's stand that the Commission, the commissioner had processed all the claims and the amount of settlement was found to be in surplus. This reinforces the position that the settlement amount was sufficient. The responsibility was placed on the union to take good on the deficient and to take out the insurance policy, and they did not do so. This is a gross negligence on their part. It was known that the medical facilities will have to be extended to the people who had who were the victims of this particular policy, and this cannot be a ground to seek an enhancement of the compensation, is what the topmost court of the country, as the Constitution Bench has said. So it's a big blow to the central government, right. But definitely it has been said that the amount that is lying pending with the Reserve Bank of India of around 50 crores should be used to settle down any kind of claims that are left at this point of time for the victims of the Bhopal gas tragedy. So somewhere or the other, though it's a little relief for the Bhopal gas tragedy victim, but then there is no enhancement of the compensation that is going to take place.
Tell us also, Ananya, I believe senior advocate Harish Salve appeared for the Union Carbide successor firms. Can you tell me what he submitted?
Well, Mr. Harish Salve actually appeared for these firms and told the Supreme Court that the government of India never suggested at any time that the settlement was inadequate, and in fact the depreciation of rupee cannot be taken as a ground to in fact enhance the compensation. While on the advocate Karun Anandi, who was appearing for the victims of the Bhopal gas tragedy, had told the court that there has been the suppression of facts by the Union Carbide, which is now Dow Chemicals, and so that the strikers at the root, which strikes at the root of the settlement company initially offered, In fact, the successor firms of the Union Carbide also told the apex court that the depreciation of the rupee since 1989, when a settlement was actually arrived at between the company and the central government, cannot be a ground to now seek a top-up of this particular compensation for the victims. Is what the arguments were. The Supreme Court heard these petitions for a very long time. The curative petition was filed by the central government. But at the end of it, the Supreme Court has now dismissed this curative petition that has been filed by the central government. Toya.
Okay, Ananya, thank you for bringing us context. A particularly important update coming in. Right now, we're going to move to our top story through the day, developments that took place yesterday and continue to take place in the Parliament.